So good morning, Jack. I thought this morning that we could start by discussing the ruling that the court issued yesterday in the deportation case. I would like to have you explain that and maybe have a few questions for you about that. And then we can proceed from there to talk to this broader question that's been raised about the performance of administration lawyers in court. Uh, Obviously connected in some way to any cases currently before the court, but let's start with that. Talk about what the Supreme Court did yesterday. How should we read it?
Sure. Last night, or I guess it was last night, the Supreme Court vacated two temporary restraining orders that Judge Boasberg had issued, constraining the implementation of the president's proclamation under the Alien Enemies Act, uh, declaring that members of a certain Venezuelan designated terrorist organization could be removed from the country. And the court vacated Judge Boasberg's orders. And basically, there were two central holdings, and there was a lot. This is an emergency order. It was basically the court just vacating lower court orders, but in a couple of pages, the court made a lot of law, in my opinion. First thing it held, and something that's been highly criticized, is that habeas corpus, as opposed to proceeding under the APA, that habeas corpus was the sole remedy, and therefore writ of habeas corpus is something that an individual brings to challenge the legality of the detention, or in this case, the legality of the transfer. And the court held that basically these cases had to be brought in habeas, and that means they have to be brought where the detainees are located, which is in Texas or Louisiana, I believe. I'm not sure. So basically, the case is going to be taken away from Judge Boasberg, and that's one central important point. Another hugely important point, though, is along the way, the court said that something that the government had challenged, and the court, excuse me, let me say that again. The court said a lot about the nature of judicial review here that these detainees get. And I just want to read from what the court says because it's pretty extraordinary in my opinion. First, the court said that the individuals subject to detention and removal under the Alien Enemies Act are entitled to judicial review as to questions of interpretation and constitutionality of the act, so they can challenge the interpretation of the act, and there are various legal issues there, and the constitutionality of the act, and they can challenge whether he or she is in fact an alien enemy and in 14 years of ages or older, which is what the statute says. So that's important, but even more important, the court said the detainees must receive notice after the date of this order that they are subject to removal of the act. They can't be whisked out of the country without getting notice. And also, the notice must be afforded in a reasonable time and in such a manner that will allow them to actually seek habeas relief in the proper venue before such removal occurs. So in sum, the bottom line is it has to be brought through habeas, but the Trump administration cannot just pick people up and whisk them out of the country as they were trying to do to circumvent the process Judge Boasberg had started. They have to be given notice and an opportunity to bring a habeas case.
You said this was extraordinary. What the court said here was extraordinary. Was it unexpected in your view? Are you
Well,
surprised by the outcome?
here's why it's extraordinary. Justice Sotomayor, in her dissent, rightly questions whether this very important, complicated ruling about the exclusivity of habeas, that there was a lot of complexity there, whether that should have been decided on the emergency orders docket with truncated briefing and no oral argument and the like. It's a fair point. It's a complicated issue. But also, what she didn't say was the court also decided some hugely consequential issues of judicial review on the emergency orders docket, points that the government had contested. And the court unanimously said this. I mean, technically, it might have been dicta in the majority opinion, but it's quite clear, and it was said several places across several opinions, that every justice on the court believes this. And I do think, I mean, I don't know whether that was expected or not or surprising. It's an extraordinary ruling, kind of on the merits, so to speak, even though it might be dicta, on in an emergency orders posture. So I don't know what I expected, but it's both of these rulings are extraordinary on the emergency orders docket. But I don't think we should. There are implications we can talk about of these rulings, but I think it's hugely important that the court said that unanimously.
So behind the headline, in fact, this is a significant loss for the administration.
I think the administration will view it. I do, given I haven't gone back and looked at every single statement they made, but they were making extremely aggressive claims along the way, which they were altering along the way about the unavailability of judicial review on various dimensions. And they've been acting as if they can just whisk people out of the country without giving them notice. So I do think that the administration perhaps won the battle by getting this move to habeas, but I think it suffered significant losses on the judicial review point.
And do you want to say anything more? You mentioned implications, anything more about, how to see the way this is going to play down the road?
Sure. I mean, so the dissent makes a big deal out of the fact that now that these detainees are going to have to get lawyers and bring these habeas cases. And that's a serious question, whether they'll be able to get lawyers, and they need to get lawyers to be able to challenge these cases, because the advantage of the procedural posture in the district court in DC was that it was a class action, and that the legal issues could be resolved in one proceeding by one set of lawyers representing everyone. So now that this means that the detainees are going to have to get lawyers. On the other hand, and this maybe will preview what you're going to be saying, the Justice Department is going to have to defend hundreds of habeas petitions. And there will be many issues, common legal issues, but every one of these are going to be factually complicated, and the government is going to have to litigate them and defend them in habeas. And given the shriveled and not always competent functioning of the Justice Department right now, that's going to be a significant challenge. So I don't want to say this is a giant win for either side. I just think it's very complicated, and the court decided a lot on the emergency orders. I will say this. I mean, one more thing I'll say, and then we can move on perhaps. Um, One consequence of this is that these issues are going to be decided basically in the Fifth Circuit rather than the DC Circuit. And that circuit is much more conservative, and everybody thinks they're going to be much more favorable to the government. And maybe so, but my view is, while that is significant, on the legal issues, nothing's going to happen until the Supreme Court weighs in. I mean, the Fifth Circuit can say and do what it wants, but I don't believe that the court is going to allow people to be taken out of the country pursuant to Fifth Circuit legal interpretations until it weighs in. So that's what I would say about that.
So the long and short of it is how this is all going to go. It's going to take some time to sort out.
Yes, I think it's going to take time to sort out. You can see what the court did here. I wrote a piece about temporizing, how the court is trying to slow things down. And you can see what the court did here as slowing things down. It basically it gave the government the win on venue, but now these things are going to have to be litigated in an individualized basis. And I don't think that the AEA is going to be the kind of really quick mechanism for removing people that the Trump administration hoped. So I do think this has the impact of slowing the case down significantly.
Well, so that brings us the slowing it down in the hundreds of cases, and what you just said about the department being stretched thinly. There was a piece today in the New York Times about the stresses on the Department of Justice, the absence of, frankly, an adequate number of lawyers to deal with all of the challenges they're currently facing, and the defenses that they're required to make of very aggressive positions they're taking in the courts. And of course, in the case of Abriego Garcia, who was removed to a supermax prison in El Salvador, even though his administration conceded that he was lawfully in the country and that the removal was lawless. We have the extraordinary situation where, in a hearing in court, the lawyer for the administration couldn't answer fundamental questions about why it was that the administration couldn't comply with an order to have Mr. Garcia return to the United States. And he said he didn't know, and he was frustrated too. I'm obviously paraphrasing, and he would do what he could to clarify matters with the client. The Department of Justice promptly suspended him. Apparently, not apparently, but I'm paraphrasing now, on the basis that his behavior in court, the defense was insubordinate in some fashion, that he wasn't doing what he was instructed to do. So you have in this Times article a depiction of a department that's under tremendous stress. Lawyers who are being asked to defend positions they don't feel comfortable ethically or as a matter of personal conscience defending. So this disarray, it seems to me, goes back to something that you and I have written about, which is it doesn't help them in court to have the administration's legal structure, its defense structure, if you will, presenting in this fashion. But are we overstating the case? Does it matter?
I do think it matters ultimately how well they litigate the cases. I mean, how well they, in the briefing and in the oral argument, the extent to which they can make persuasive arguments. A lot of these lawyers have been clearly struggling to be on top of the cases, but and for a whole bunch of reasons, some of which you mentioned. I do think it also has to matter, I mean, at the margins, at least, when judges are making decisions and the lawyers before them can't give candid or full answers because their client won't reveal them. I just don't see how that could help the government's case.
I agree. I also think this administration that's being so aggressive, and maybe I'm overstating the case here, the appearance that the administration is sort of bullying the lawyers, that is getting in the way of their ethical professional discharge of their duties is also a very poor look. I mean, quite apart from their going to court being apparently unprepared, not able to competently defend the administration's position, this tension between the senior ranks and the lawyers who were expected to do the heavy lifting in court just betrays something about the administration's kind of posture in these matters that I think is very damaging to the government.
Yeah, and let's just put it in a little bit broader context. I mean, career government lawyers show up in court and defend an administration's position, whether it's a Republican or a Democratic administration. And that's what they do, and they're professionally trained, and that's what their job is. So it's not like these lawyers are going in and trying to undermine the government. They're trying to defend the government's position, but they're being put in an impossible position where they're basically, just to say it in brief, they're basically being asked to defend the government without full information and without being able to make arguments that are or address arguments that are pertinent and relevant to what the judges are interested in. So this is it's a very unusual situation, and it can't be good for the government's success in these cases.
Yeah, and as an ethical matter, I would just note when a lawyer, I don't have the transcript in front of me, but when a lawyer is being questioned by the court, is being expected to provide answers, the lawyer has an ethical obligation to be candid with the tribunal.
Yeah,
And so you could take from this episode the appearance that the lawyer was punished for being candid with the tribunal, not just unprepared and unable to answer the questions from the court, but in the course of acknowledging to the court that he didn't have the answers that the court wanted or needed, he faces discipline. I mean, how does that work?
I don't know. I mean, I thought that he faced discipline in part because of the acknowledgement that the government messed up or something like that. Was that I didn't follow this story deeply. Was that part of the problem, that he was honest about, even though the government kind of said in a passing sentence in the brief that it was the deportation was done by mistake? I mean, wasn't that also part of that honest, candid acknowledgement? Wasn't that part of the reason for the punishment?
Unclear what actually the department
See,
was most reacting to here, although it's really hard to say why he should be disciplined for, as you pointing out, acknowledging what everybody knew to be the case, which was the order was lawless. I mean, it was a violation of a clear protection in place for this particular individual. So it's not clear to me how that would prompt discipline of that lawyer, but that's the look of it.
yeah. Can I tie the Garcia case back into the Alien Enemies Act case?
Yes, of course.
So in that case, just to be brief, someone was by mistake taken out of the country. And the question is, the district court, in an order, basically arguably ordered the government to get the person back into the United States. And there was a question in the Court of Appeals that was considering a stay application, whether that was an order to the government to get the person back or an order to make best efforts to get the person back. And that case is now before the Supreme Court on an emergency order. The Chief Justice, I think, issued an administrative stay. There's been a temporary stay of the case while the court is considering that emergency question. But as Justice Sotomayor pointed out in her dissent from the Alien Enemies Act case, that is a hugely important question for what the court said in the Alien Enemies Act case. Because if the government can, the Supreme Court said the government had a duty to give someone notice and opportunity to be heard fully before deporting that person. But if the government ignores that and just sends the person out of the country, and the person is now in the foreign government's hands and the government doesn't have any duty to bring them back, that creates an extremely awkward situation to put. I mean, and and it's not beyond imagination that the Trump administration would play that game. So what the court says in this, again, emergency order posture about this question, and it's a very complicated legal issue about the nature of judicial control, then the extent to which courts can order the government to send someone back to this country who is illegally deported, complicated legal issue. It's once again raised on the shadow docket, the emergency orders docket. And it really goes to the core of how courts will be able to uh, assess the legality of these deportations.
Okay, very good. Well, we'll wrap on that today.
Thanks, Bob.
Thank you.